Hello everyone, I am Rusha Mukherjee, a student of Hyderabad Law College and an intern at LEXIS and Company. Today I am going to discuss about the Aadhar case, which was the very lengthy and a very important case decided by the Supreme Court. It had decided that whether the right to privacy was our fundamental right and also whether the Aadhar Act violated the right to privacy. To make the Aadhar, a special body was made, that is the UIDI, and the Aadhar took all our biometric informations, that is the retina scan, the fingerprint scan, and everything was kept in the central server of the central government. It was aiming to curb the corruption and to make the public services more efficient. But slowly what happened was, it was being made mandatory by the government in various ways, such as the welfare schemes like the midday meal or any other places. It was made compulsory. Now, it was not only made compulsory here, it was also made compulsory in the bank accounts, for the school admission, for anybody, even to get a mobile SIM. Anybody, whosoever, could actually, by only clicking once, get the person's entire information, because now the Aadhar card was being linked to the bank accounts as well as with the mobiles. And so, there was absolute chance of misuse of this information. Earlier, even if the police wanted to take a search of the house, he had to take a search warrant and follow various steps before doing that. But now, everything was very easy in the digital world. And hence, it actually threatened the people's privacy and security also. For the fact whether the right to privacy is a fundamental right or not, certain cases had already been decided, like the MP Sharma and the Kharag case. These cases felt that the right to privacy was not the fundamental right. The second question that this act told was whether the Aadhar provisions or the Aadhar Act was valid or not under the Constitution. After many arguments were put before the Supreme Court, like the case Puttasamy had argued that the data in the central server was not regulated to be used. It had no safety measures. There were no schemes to protect it. And secondly, all the welfare schemes that was there was itself fundamental right. And so, any restrictions cannot be put in them by making Aadhar mandatory for all these cases. On the other hand, the second question, that whether right to privacy is a fundamental right, was answered in the assertive by the Supreme Court, because the right to privacy had its meaning incorporated in Article 14, 19, 20, 21 and 25. It also told that the Kharag judgment was not correct, and the right to privacy is a fundamental right, because many of the United Nations declarations also imply that the right to privacy should be a fundamental right. And regarding the Aadhar provisions, the Aadhar Act was held to be valid on 26 September 2018. But even then, it told that giving biometric information does not violate the right to privacy. But many of the provisions had either been amended or been removed from the Aadhar Act, like Section 57, Section 33(1) or Section 47. And as of now, all of us have the right to privacy, and it is actually as important as any other fundamental right. And hence, Aadhar or any other biometric information cannot be made mandatory in the present scenario. Bye bye. Have a nice day. Please let me know how do you like my video. That's all for today. Thank you.